everyone. Thank you for joining Ash Carl. Today, we're going to be talking about shareholder disputes, which are unfortunately very common. So, just a quick disclaimer, this is just general information, not legal advice. I will be presenting. My name is Charles Miller. I'm a senior associate here with the firm. It's a pleasure to be once more hosting our series with everyone today. And I am here on behalf of Ash Carl. This is a firm that's been in practice for many, many years, and we do all sorts of bespoke litigation and business-related practices. We are dedicated to resolving all of your business disputes, be that if it arises litigation, but certainly, as today's presentation will show, we're there to prevent these problems from happening to begin with. Without further ado, let's launch into why shareholder disputes matters. But first, let's discuss what are they to begin with. A shareholder dispute essentially arises when two or more people in the company or two more shareholders have a disagreement about the vision of the company or the next steps a company should take. Often when you start a company together and you have an exchange of shares and who has what level of ownership, you're usually aligned with where you want things to go. But as the business evolves and grows, eventually problems will arise. When a shareholder dispute does arise, it can have a major impact on business operations and the reputation of the company. Specifically, if you have a shareholder dispute, it can often stall or stop business operations. And anytime there is a break or stall in business, that causes reputational harm. As you know, your clients and vendors require fluid and clear workflow. And if there's for stoppage, people might take their business elsewhere. Another one is there's some legal and financial risk for the company. As I mentioned before, if you have a reputational risk, people will take their business elsewhere. That's a financial risk right away for the company. But shareholder disputes can also have legal implications. If one shareholder believes as though that they have been treated unfairly, or under the business code we call it an oppression, they have the ability to bring an oppression claim in civil court against the other shareholders or against the company altogether, such that these shareholder disputes can manifest or evolve from day-to-day disagreements to full-fledged legal actions against people that you used to be in business with. That alone is its own financial risk too. And so for a shareholder dispute, what we're going to really emphasize today is the importance of proactively preventing these types of conflicts, proactively having resolutions in place and mapped out so there's no real issue when these types of disagreements do emerge. So there are a couple key triggers for when a shareholder conflict might manifest. The biggest one that we've seen is disagreements over financial performance and dividends. As they say, money can be the root of all evil. It certainly does tend to trigger a lot of emotional disagreements between people who usually get along together. And so in shareholder disputes, where a big purpose of starting the company is, yes, by and large, to either deliver a product or a service, but the end result is you want to be financially compensated for what you've done. And so shareholders can sometimes disagree over how a company is doing. Maybe some minority shareholders want to know, disagree, think that the company's doing better than it's being reported, or have a suggestions doing worse than it's being reported. They might even have a disagreement about how dividends are being paid out. And dividends, of course, being after a company's done certain well, they can start paying out a financial contribution to all of those who are shareholders. Sometimes people who are expecting a higher dividend payout than they receive can raise some concerns. Another key area is the actual ownership and voting right of the company. Often when you form a company together, you have an idea of who's going to really be at the helm of the ship. Unless it's a clear 50-50 split between the shareholders in terms of everyone's kind of in charge together, sometimes there is one person who you trust to really be at the helm. But those people, how much control they have the company might be misunderstood. They might overstep if you think that they made too many decisions that they shouldn't be done. Or if you're a minority shareholder and you want to have a say in what the company does, as you really want to, if you buy into a company, even if you're a minority shareholder, you want some say over what the company does. Disputes can arise if you think that your voice isn't heard. And that leads us into, a lack of communication transparency. You've probably heard it all the time, and I've said it here as well, that communication is the key to all healthy relationships, be it romantic, be it family, and certainly be it business. or a lack of communication can lead people to assume all sorts of nefarious deeds are going on. If they, especially if they're expecting a much higher dividend payout, if there's a little bit of a cloud over how financially healthy the company is, they're going to start to assume the worst. If a business decision is made that they didn't agree with, but there wasn't any communication with why that business decision was made, shareholders might start to get up in arms with each other. And lastly, and a fairly major one, is a breach of fiduciary duty. This is a massive breach when it comes to a shareholder conflict. Fiduciary duties as well. A fiduciary duty is essentially an obligation that you have to work in the best interest of the company. If you are a director or C-suite, chief operating officer, chief financial officer of the company, and certainly if you're a shareholder of the company, you have a fiduciary duty to look after the best interests of the company above your own private ones, such that if you come to a decision where you can benefit the company and you choose not to, or benefiting something else to the detriment of the company, you would have a breach of fiduciary duty, and that certainly will trigger shareholder conflicts as they break down. Another one you might see with some shareholder disputes is if the company is going insolvent or bankrupt, where we talk about how to actually divide the assets of the company. Certainly, a business relationship often has a shelf life. Companies and corporations you might start together, you might certainly intend for them to last forever, or you might know they're only going to last for about 5 to 10 years. How you dissolve that, if it's either going to bankruptcy or just a straight dissolution of the company, how you carve out who gets what can certainly lead to a major conflict between shareholders. So, now that we know about some triggers that could happen in terms of shareholder disputes, and we know that they can have a massive impact on the financial health of the company, as well as the reputational health, and ultimately can lead to some serious consequences, how do we avoid it? Preventing a shareholder dispute starts with drafting a very strong shareholder agreement. Now, drafting a shareholder agreement should start at the inception of the company. So when you and your friends get together, you're drafting or creating this company, you should speak with a lawyer and have them draft up a formal shareholder agreement. Now, I know that me saying this is quite the killjoy. Forming a business with somebody, you were excited to start a service, to deliver a product. You were excited about these ideas. Entrepreneurs and business owners, you guys are wonderfully talented. You create something out of nothing, you deliver a service, you're genius. And so as the boring lawyers, we're going to tell you that you also need to look after for yourself, because future you will thank current you for drafting a shareholder agreement. Shareholder agreements essentially outline what the ownership of the company is, what the roles each person are, as well as the decision-making powers. These allow people to have a fulsome, clearly written idea of what the company is going to do, who's going to do what within the company, as well as who is at the helm of the ship and what decision-making powers are there. For instance, sometimes when you have a dissolution of the company, you'll see complaints of sweat equity, where someone talks about how, yes, we have a 50-50 split in the company, but I feel as though that I did more for the financial health of the company, so that now that the company is dissolving, I want a larger cut of the pie. Well, if your shareholder agreement clearly outlines, hey, someone's the chief operating officer versus someone's the chief financial officer, and these are the roles they'll participate in, these are the roles the other person has, and then each one gets this cut of the company in exchange for that, well, now we have a clear understanding that even if someone did a bit more, it was outlined in the agreement how much that bit more was going to benefit them. Decision-making powers are also important to outline as well. Again, sometimes it's good to have someone at the helm of the ship to make some decisions, but you should also allow for some other people to have a say in some other decisions. Making sure that that is clear allows you to avoid any misconceptions down the road. And if those misconceptions do arise, in your shareholder agreement, you should have a conflict resolution mechanism. This is, which we'll go into a bit more detail a bit later, but a conflict resolution mechanism allows you to decide that if a conflict arises, how do we resolve it? If there's a dispute about the price that we set for something, if there's a dispute about the share value, dispute about lack of communication, what do we do to resolve it? It's good to have resolution processes in place at the start of the company, because if you don't have them there and you start to have a dispute, now you're trying to talk to somebody who's upset with you while trying to also decide how to best resolve the dispute. Having that in place at the start is very important, as almost like a prenuptial agreement. Again, no one gets into marriage thinking about the roles, thinking about ending the marriage. But it is very important, helpful, should the relationship dissolve, even if it dissolves amicably. Same thing with shareholder agreements. You don't draft the shareholder agreement necessarily with the idea of when we dispute, this is how we're going to resolve it. But a shareholder agreement clearly outlines what everyone expects and how to resolve a conflict when it does arise. And the shareholder agreement should be a living document. That means regularly reviewing and updating this agreement, because the law evolves, the law changes, and your company evolves and changes. You might have a shareholder agreement that's great for 2 to 4 people, but when your company evolves to a 15, 50, or 100-person business, maybe your company goes from private shares to now public shares, or you start to open up into an international market. The shareholder agreement for a smaller company isn't going to fit for the larger one. You'll need to update this agreement, and you need to have a venue for how to do that. So having a lawyer regularly review and update the agreement is very critical. Your agreement is not only clear and concise, but healthy and grows, just like your business. So there's an important avenue when we have a dispute. So let's say here we've got a great shareholder agreement, but now it seems as though that people are starting to disagree. Well, a key channel or a key strategy to avoid shareholder disputes is to actually have open and honest communications. Making sure you have established a clear channel for shareholders to raise issues. Maybe you have a monthly or a semi-annual shareholder meeting so everyone can come forward. Having agendas on those meetings is very important, so that everybody attending these shareholder meetings know what you're going to talk about and you have the answers available. It's very important to have the agenda. I'm going to really emphasize this, because if you show up with an agenda, it becomes a Wild West. Anybody can bring any topic forward that they want, especially it could be a topic you're not prepared to answer. They could have concerns about the financials, that you don't have the financials before you. They could have concerns about a new product and you don't have the product details before you. In law and in business, you want the answers. This isn't a television series where you get the drop on somebody and ask them a question they don't know the answer to. That doesn't actually solve anything. You want to be able to ask a question and get an answer, not show that the other person's unprepared. That's not conducive to business and certainly not conducive to law. We would encourage in your shareholder agreement and in your company to have transparency with financial reporting. Your shareholder agreement might be a structural flow of how money should move through the company. So, you deliver the product, you deliver the service, money comes in, how do people get paid out, and how does the money feed into the health of the company? Making sure that that is transparent for everybody to see will help eliminate any sort of concern someone might have that the company is not being managed well, or that they don't know about the financial health of the company. As a shareholder, you do have a right to know the financial information and accounts of your company, at least annual reporting you're owed. Making sure that that is openly transparent will save you a lot of headaches down the road. We also have here, practice active listening during disagreements. You may have heard that a lot in relationship psychology. It is still relevant even in business psychology. If someone raises a concern to you, a shareholder or minority shareholder or just another director, they might come to you with a problem, and if you simply shut them down, you're not going to get a resolution. Making sure you're listening to these concerns and actively trying to figure out where that concern came from, you're more likely to find a solution. And sometimes when someone raises a concern, they might not be raising a concern that is actually manifest, and it will allow you to identify what the real problem is. So make sure that when concerns are raised, you don't take it personal. You listen to what they have to say. From there, you can negotiate and navigate a solution. Now, beyond a shareholder agreement, there are legal protections and dispute resolution options should a disagreement. So in law, under legislation, you got the Ontario Business Corporations Act, you got the Canadian Corporations Act. There are a recognition of shareholder obligations and fiduciary duties. Again, fiduciary duties and shareholder obligations are largely the same in terms of the principle behind it is an obligation to look after the health of it. So shareholders can't go rogue and look after their best interest to the detriment of the company and the detriment of the other shareholders. That includes majority shareholders. If a majority shareholder moves forward and changes the dividend payout structure such that only the Class A majority shareholders get dividends, and then all of a sudden the minority shareholders don't get anything. Well, now we've got legal oppression remedies to bring forward. That's under Ontario law. There's some federal law for it as well, and other provinces also have their own classes for it. The fact is that the law does govern it. There's also options for litigation and arbitration. If you have a shareholder dispute and there's no way forward amicably, you can eventually look for solutions in the civil court. You may also have arbitration agreements that are baked into the resolution process of your shipment. We don't recommend litigation, is very expensive, as is arbitration. It's always best to proactively avoid these as much as possible. But the good news is that if it goes down there, you do have legal remedies available to you as well as legal defenses to you. For instance, if you are the majority shareholder and you make a business decision, or let's say specifically you have the ownership control of the company, you have the right to make a business decision. If that business decision is ultimately detrimental to the company, but you made it in good faith, well then, frankly, you have a defense there. The courts do allow you to defend yourself and say that even a decision that ultimately wasn't good for the company was made in good conscience, was made for the benefit of the company. There's also legal considerations for business value disputes. Specifically, what that means, if there's any disagreement about how much the company is worth, or how much the shares are worth, or what the financial health of the company is, there are legal revenues there. In fact, under the OBCA, there is options for ordering and auditing. We won't take you through the specific sections there, but there's a lot of power Ontario legislation offers for shareholders to both defend themselves and advocate for themselves. It's established today in terms of how to understand and protect your business from shareholder disputes. The importance of proactive measures can't be emphasized enough. We talked about drafting a shareholder agreement. Please do speak to a lawyer if you're planning on starting a business about creating a shareholder agreement. Even if you haven't decided yet if you want to necessarily have shares in the company, having a lawyer, just one here, look over how you want that relationship to be navigated and defined can really be helpful to you. Utilizing the shareholder agreement is also very important. Once you have the shareholder agreement, that's your playbook for any dispute. That's your playbook for any sort of disagreement. It's also your playbook for how the company might grow. If somebody wants to buy in more shares, having something there to help assist you will also be beneficial. We also recommend seeking legal advice early in disputes. Once a dispute is raised, the next steps you take are critical to a quick resolution and so not stepping into a quagmire of problematic scenarios. If someone raises a shareholder dispute, having a lawyer look over the agreement, looking over the dispute, you can probably get a resolution very swiftly, or at the very least, protect your company and your business from a major dispute down the road. But a good way to avoid disputes is establishing a culture of transparency. Making sure everyone knows what the company is doing, making sure everybody knows what the responsibility of the different corporate leaders are, allows people to know, have that meeting of the minds early on, to know this is what the company is meant to do. This is how the money is supposed to flow through the company. This is everyone's role in the company. Making sure that all of that is clear and transparent makes it so that it's very little for someone to latch on to if they have a complaint, especially if they agreed to this structure early on. If this is very clear from the start and you work with people who all understand the agreement and sign off on it, there's a very real chance, and again, I can't guarantee it, but there's a very real chance that you'll avoid any sort of dispute down the road, or at the very least, if a shareholder dispute does manifest, you can navigate it swiftly. The first question that was sent in is, if I make a good business decision, but due to things out of my control, there is a business loss, can I be responsible? I actually mentioned this a little bit earlier, so I made your question. The answer is, it depends. But by and large, under the OBCA, directors and business owners do have a healthy defense of honest business decisions. We all know that business ebbs and flows. Sometimes the best business decision can go. Marketing can really impact things. The global economy can impact things. There's lots of reasons why a great business decision didn't manifest in financial health of the company. That's not going to, you're not going to be held responsible. Or at the very least, you have a defense for it. They'd have to show out levels of gross negligence to really get that moving. Thank you for that. Next question, what should I do if someone wants more shares in the company, but I don't want to relinquish control? Is that a shareholder dispute? Excellent question. So if you start a company, you have a shareholder agreement, let's say you have a good balance of shares. So let's say you're 60 and the other person's 40, but now they want more shares in the company. But you don't want to relinquish control. You don't want to go into a 50-50 where you both have equal say in the company. That could cause a problem if you don't have someone at the helm of the ship to lead something forward. So what should you do? This is where active listening plays a role. Really look at what they want when they want more shares. Do they actually want a bigger say in the decision making, or do they want more equity? Do they want a larger dividend payout? When they ask for more shares, there are ways that you and your lawyer can actually structure and augment the shareholder agreement. You might be able to create different class of shares, where one class of share has the voting rights and has the control, where another class of share is just there for the dividend payouts. That might be one solution. Another solution is for giving someone more say in only certain aspects of the company. So in terms of the day-to-day operations is one thing, but then maybe for major purchases is another. It will always depend on your circumstances and your business circumstances to decide what is the best course of action, but actively listening to what they want. You and your lawyer can craft something so that everyone's satisfied. Next question. If I don't have a shareholder agreement, but have shares and multiple owner shareholders, can I introduce a shareholder agreement later, or can that only happen at the start? So we really suggest having a shareholder agreement at the start. Have that when the company's first formed so that no disagreements can go unanswered down the road, or at least as many of them can be dealt with. It's good to have that established, because even when you form the company and you think you have a meeting of the minds, where you think everyone's on the same page, people can have completely different visions for the company, can be speaking different languages and not really aligning properly. Once you have it in writing, it becomes clearer. But the reality is that a lot of businesses are done on a handshake. And as much as lawyers beg and plead business owners to please put everything in writing, we are well aware that that does happen. So you come to a point where you have the business is operating, you've got shares, but you don't have a shareholder agreement. Can you introduce one? The answer is yes. You can certainly now introduce a shareholder agreement, but you will have obstacles in your way. You are now been operating the business for a while, and if you want to introduce a shareholder agreement and somebody has been operating under different assumptions this whole time, well, that's really going to come to the fore. Unless the two of you are completely aligned, or you and all of your business aligned, for the most part, you're likely going to see some disagreements really emerge. We would recommend in these scenarios, bring a lawyer on board to help draft a shareholder agreement. Every shareholder agreement, if I didn't emphasize this before, is bespoke and special to every company. There's not really a boilerplate shareholder agreement that exists. Every company is different, every company structure is different, and every shareholder agreement, therefore, has to be different. Having a lawyer craft something that's perfect for your company is going to be important here. So certainly you can introduce a shareholder agreement later on, but you're going to need to get everyone on board to make sure that that is navigated. And having a lawyer there to assist you will be critical to this. Next one. If there's no shareholder agreement when we start the corporation several years later, one shareholder agreement is divorcing with wife. The wife wants to claim a portion of his shares. Now everyone isn't happy. How to prevent happening? Um, it's a great question. So the preventative is to have the shareholder agreement in place first in terms of one thing that you can have in a shareholder agreement is how to deal with somebody leaving the company altogether, or how to deal with somebody who might be in a divorce scenario and their spouse is seeking to get a cut of those shares. You can have a shareholder agreement that carves out if somebody needs to exit, you can lead away in terms of this is how they sell their shares. You might have a right of first refusal for the other shareholders so that they can purchase these shares at a certain agreeable price. Having a regular audit so you always know the share value is very important. This can allow it that if you're in a scenario where somebody needs to sell their shares or their shares are part of a family law dispute, you can help navigate, protect the company while dealing with what do you do with the others. In this claim here, it looks as though that we don't have a shareholder agreement, but the wife wants to claim a portion of his shares. That's going to delve into like a relationship between family court, the family law, which unfortunately is a bit out of scope here, as well as with corporate law, which is in scope here. Without a shareholder agreement, it becomes very difficult to navigate who has control of what shares. If this particular spouse wasn't part of the original business arrangement, then there's an argument that could be made that perhaps they aren't entitled to these shares. Or perhaps if there is a straight split in terms of finances, this spouse might be owed a certain payout of those shares. The way it can be avoided is having a shareholder agreement in place first, but the way this can be navigated now, bring a lawyer on board. There's a little bit more going on here. I highly recommend hiring a lawyer to navigate it. There are solutions forward, fortunately, but it's going to involve some very easy. If you guys have any further questions, or you have some specific legal questions, like our last question there, send us an email. We would love to set up a consultation with you. We can certainly go through your circumstances in terms of how to navigate your shareholder dispute or how to draft a shareholder agreement for you. Although we recommend always having a shareholder agreement, we know that that's not always how business operates. But don't worry, we can navigate shareholder disputes quite efficiently and specific to your case. Sometimes a shareholder dispute is just business, and you're not looking for something emotional. You're looking for something that's a clean cut. We can assist. And sometimes there is emotion tied up in it, and that's fair. And a lawyer can help you navigate that as well so that there is an equitable or fair resolution across the board. And so that you can take a step back, focus on your business while allowing your lawyers to help you navigate and give you the best advice, which is absolutely what we are here to do. So with that being said, thank you all for turning in this afternoon.